Commercial Law. Revised Corporation Code of the Philippines. Republic Act No. 11232. Title II Incorporation and Organization of Private Corporations. Section 10. Number and qualifications of incorporators. Any person, partnership, association, or corporation, singly or jointly with others but not more than 15 in number, may organize a corporation for any lawful purpose or purposes, provided that natural persons who are licensed to practice a profession, and partnerships or associations organized for the purpose of practicing a profession, shall not be allowed to organize as a corporation unless otherwise provided under special laws. Incorporators who are natural persons must be of legal age. Each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock. A corporation with a single stockholder is considered a one-person corporation as described in Title 13, Chapter 3 of this Code. Section 11. Corporate Term. A corporation shall have perpetual existence unless its Articles of Incorporation provides otherwise. Corporations with certificates of incorporation issued prior to the effectivity of this code and which continue to exist shall have perpetual existence, unless the corporation, upon a vote of its stockholders representing a majority of its outstanding capital stock, notifies the Commission that it elects to retain its specific corporate term pursuant to its Articles of Incorporation. Provided that any change in the corporate term under this section is without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this code. A corporate term for a specific period may be extended or shortened by amending the Articles of Incorporation. Provided that no extension may be made earlier than 3 years prior to the original or subsequent expiry dates unless there are justifiable reasons for an earlier extension as may be determined by the Commission, provided, further, that such extension of the corporate term shall take effect only on the day following the original or subsequent expiry dates. A corporation whose term has expired may apply for a revival of its corporate existence, together with all the rights and privileges under its certificate of incorporation and subject to all of its duties, debts, and liabilities existing prior to its revival. Upon approval by the Commission, the corporation shall be deemed revived and a certificate of revival of corporate existence shall be issued, giving it perpetual existence, unless its application for revival provides otherwise. No application for revival of certificate of incorporation of banks, banking and quasi-banking institutions, pre-need, insurance and trust companies, non-stock savings and loan associations, NSSLAs, pawnshops, corporations engaged in money service business, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency. Section 12. Minimum capital stock not required of stock corporations. Stock corporations shall not be required to have minimum capital stock, except as otherwise specially provided by special law. Section 13. Contents of the Articles of Incorporation. All corporations shall file with the Commission Articles of Incorporation in any of the official languages, duly signed and acknowledged or authenticated, in such form and manner as may be allowed by the Commission, containing substantially the following matters, except as otherwise prescribed by this code or by special law. A. The name of corporation. B. The specific purpose or purposes for which the corporation is being formed. Where a corporation has more than one stated purpose, the Articles of Incorporation shall indicate the primary purpose and the secondary purpose or purposes, provided that a non-stock corporation may not include a purpose which would change or contradict its nature as such. C. The place where the principal office of the corporation is to be located, which must be within the Philippines. D. The term for which the corporation is to exist, if the corporation has not elected perpetual existence. E. The names, nationalities, and residence addresses of the incorporators. F. The number of directors, which shall not be more than 15 or the number of trustees which may be more than 15. G. The names, nationalities, and residence addresses of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. H. If it be a stock corporation, the amount of its authorized capital stock, number of shares into which it is divided, the par value of each, the names, nationalities, and residence address of the original subscribers, amount subscribed and paid by each on the subscription, and a statement that some or all of the shares are without par value, if applicable. I. If it be a non-stock corporation, the amount of its capital, the names, nationalities, and residence addresses of the contributors, and amount contributed by each, and J. Such other matters consistent with law and which the incorporators may deem necessary and convenient. An arbitration agreement may be provided in the Articles of Incorporation pursuant to Section 181 of this Code. The Articles of Incorporation and applications for amendments thereto may be filed with the Commission in the form of an electronic document, in accordance with the Commission's rules and regulations on electronic filing. Section 14. Forms of Articles of Incorporation. Unless otherwise prescribed by special law, the Articles of Incorporation of all domestic corporations shall comply substantially with the form provided in this Code. Section 15. Amendment of Articles of Incorporation. Unless otherwise prescribed by this Code or by special law, and for legitimate purposes, any provision or matter stated in the Articles of Incorporation may be amended by a majority vote of the Board of Directors or Trustees and the vote or written assent of the stockholders representing at least 2/3 of the outstanding capital stock, without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this Code. The Articles of Incorporation of a non-stock corporation may be amended by the vote or written assent of majority of the trustees and at least 2/3 of the members. The original and amended articles together shall contain all provisions required by law to be set out in the Articles of Incorporation. Amendments to the articles shall be indicated by underscoring the change or changes made, and a copy thereof duly certified under oath by the corporate secretary and a majority of the directors or trustees, with a statement that the amendments have been duly approved by the required vote of the stockholders or members, shall be submitted to the Commission. The amendments shall take effect upon their approval by the Commission or from the date of filing with the said Commission if not acted upon within 6 months from the date of filing for a cause not attributable to the corporation. Section 16. Grounds when Articles of Incorporation or amendment may be rejected or disapproved. The Commission may disapprove the Articles of Incorporation or any amendment thereto if the same is not compliant with the requirements of this Code. Provided that the Commission shall give the incorporators, directors, trustees, or officers a reasonable time from receipt of the disapproval within which to modify the objectionable portions of the articles or amendment. The following are grounds for such disapproval. A. The Articles of Incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. B. The purpose or purposes of the corporation are patently unconstitutional, illegal, immoral or contrary to government rules and regulations. C. The certification concerning the amount of capital stock subscribed and or paid is false, and D. The required percentage of Filipino ownership of the capital stock under existing laws or the Constitution has not been complied with. No Articles of Incorporation or amendment to Articles of Incorporation of banks, banking and quasi-banking institutions, pre-need, insurance and trust companies, NSSLAs, pawnshops and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency to the effect that such articles or amendment is in accordance with law. Section 17. Corporate name. No corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law, or when its use is contrary to existing law, rules and regulations. A name is not distinguishable even if it contains one or more of the following. A. The word corporation, company, incorporated, limited, limited liability, or an abbreviation of one of such words, and B. Punctuations, articles, conjunctions, contractions, prepositions, abbreviations, different tenses, spacing, or number of the same word or phrase. The Commission, upon determination that the corporate name is 1. not distinguishable from a name already reserved or registered for the use of another corporation, 2. Already protected by law, or 3. Contrary to law, rules, and regulations, may summarily order the corporation to immediately cease and desist from using such name and require the corporation to register a new one. The Commission shall also cause the removal of all visible signages, marks, advertisements, labels, prints, and other effects bearing such corporate name. Upon the approval of the new corporate name, the Commission shall issue a certificate of incorporation under the amended name. If the corporation fails to comply with the Commission's order, the Commission may hold the corporation and its responsible directors or officers in contempt and/or hold them administratively, civilly, and/or criminally liable under this code and other applicable laws and/or revoke the registration of the corporation. Section 18. Registration, incorporation, and commencement of corporate existence. A person or group of persons desiring to incorporate shall submit the intended corporate name to the Commission for verification. If the Commission finds that the name is distinguishable from a name already reserved or registered for the use of another corporation, not protected by law, and is not contrary to law, rules, and regulations, the name shall be reserved in favor of the incorporators. The incorporators shall then submit their articles of incorporation and bylaws to the Commission. If the Commission finds that the submitted documents and information are fully compliant with the requirements of this code, other relevant laws, rules, and regulations, the Commission shall issue the certificate of incorporation. A private corporation organized under this code commences its corporate existence and juridical personality from the date the Commission issues the certificate of incorporation, under its official seal, and, thereupon, the incorporators, stockholders/members, and their successors shall constitute a body corporate, under the name stated in the Articles of Incorporation, for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved, in accordance with law. Section 19. De facto corporations. The due incorporation of any corporation claiming in good faith to be a corporation under this code, and its right to exercise corporate powers, shall not be required into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. Section 20. Corporation by estoppel. All persons who assume to act as a corporation knowing it to be without the authority to do so shall be liable as general partners for all debts, liabilities, and damages incurred or arising as a result thereof, provided, however, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or on any tort committed by it as such, it shall not be allowed to use its lack of corporate personality as a defense. Anyone who assumes an obligation to an ostensible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation. Section 21. Effects of non-use of corporate charter and continuous in operation. If a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, its certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period. However, if a corporation has commenced its business but subsequently becomes inoperative for a period of at least 5 consecutive years, the Commission may, after due notice and hearing, place the corporation under delinquent status. A delinquent corporation shall have a period of 2 years to resume operations and comply with all requirements that the Commission shall prescribe. Upon compliance by the corporation, the Commission shall issue an order lifting the delinquent status. Failure to comply with the requirements and resume operations within the period given by the Commission shall cause the revocation of the corporation's certificate of incorporation. The Commission shall give reasonable notice to, and coordinate with the appropriate regulatory agency prior to the suspension or revocation of the certificate of incorporation of companies under their special regulatory jurisdiction.